We're not in the habit actually of playing to such a packed gallery for our usual academic meetings, but the packed gallery obviously is a testament not just to the salience of the issue that we have before us, but also the distinguished panel that we have to discuss it. We are truly honored to have with us today Mr. Ashok Desai, Senior Advocate, former Attorney General of India. Mr. Desai has an illustrious legal career spanning 6 decades. He has argued landmark constitutional and human rights cases with legal acumen, compassion and sensitivity. In the Kaushal case, he appeared for Shyam against 377. We are also privileged to have with us Mr. Shyam Divan, Senior Advocate, with a similarly distinguished legal career, albeit spanning fewer legal decades. Mr. Divan appeared for Voices Against 377, and I have it on reliable authority that his final arguments in court were truly outstanding and left very few, apart from the judges perhaps. We're also delighted to have with us the younger legal stars, Menaka Guruswamy, who briefed Mr. Ashok Desai, and Arvind Narayan, who briefed Mr. Shyam Divan. Menaka is, of course, making waves as a constitutional lawyer, and Arvind is a committed human rights advocate, co-founder of the Alternative Law Forum, a remarkable institution engaged, as the title would suggest, in alternative lawyering that's really making a difference. The Suresh Kumar Kaushal judgment delivered by the Supreme Court in December is deeply problematic at several levels. It is obviously problematic for the substantive outcome, which violates the rights, not so-called, but the rights of the LGBT community, and does so in language dripping with disdain. The LGBT community is not a minuscule minority, although even if it were, frankly, in a human rights context, that's completely irrelevant. It's not, human rights are not to preserve the majority. The judgment is also deeply problematic, I think, as many legal scholars have noted, for its complete forfeit of legal reasoning. And the shockingly poor quality of legal reasoning in this judgment is likely a reflection of the fact that judges arrived at the conclusions that they did for whatever personal predilections and biases, and then reasoned backwards. And the fact that they felt that they could do this and not be held to account for it is, I think, a function of the fact that there is societal complicity in giving them or putting them on a pedestal that they surely do not deserve to be put on. So our panelists today will speak to fatal flaws, I think, in the Kaushal judgment, as well as, I hope, also fatal flaws in the judicial system that we need to address. They will also give us a sense, I'm sure, of what lies ahead. Before I give the floor to Mr. Ashok Desai, I would like to note that I did invite lawyers who appeared for the other side, but they were otherwise engaged, were reluctant to participate in this discussion. I am very happy, though, to see in the audience Rishad Chaudhry, who was on the legal team for the All India Muslim Board, and we might call on him during the course of the discussion. So with these introductory remarks, I'd like to give the floor to Mr. Desai.
Well, friends, the High Court judgment in Suresh Kumar Kaushal against Lance Foundation is an interesting example of judicial craftsmanship. In a sense, one would think that this is a cut and dry question and can be answered without too many difficulties. But in fact, it is extremely difficult to consider the subject without a large amount of emotional overtone and the baggage that each one of us carries. It's very difficult for people who are not so oriented to understand what are the problems of those who are so oriented. Therefore, Shah and Muralidhar gave a limited order, although it served the purpose, saying the section will not apply as between adults who in private and with consent are indulging in their own, what the old English authors used to call criminal conversation. So, because you had these very fascinating words, as you will see, like criminal conversation, commerce and things of that kind, which we'll probably have to allude to. The problem is not, you will realize how difficult the problem is when the judge has to decide it. When you think of a case like Lawrence, versus the state of Texas, where I'm not going to go into the history, but I would strongly recommend that if you have an opportunity, and the library should, invest in a book called Flagrant Conduct, which is by Dale Carpenter. And the whole book is devoted to Lawrence versus the state of Texas. It's very fascinating that the total arguments in the case took half an hour each, which is the American system. We took about 30 days or more in each of the courts. And I think the quality of the argument in about half an hour, and the quality of the reasoning of the judges is perhaps merits a greater study. And what Kennedy decided was, the same problem arose. How do you decide, how do you justify what large chunks of society might regard as unacceptable conduct? Justice Kennedy, for the majority, said that there shall be no intrusion in private life. The state will virtually stop at the bedroom. And this is a very narrow and a good way of putting the issue, so that you don't go into the larger issues of what is dharma and what are the behavior patterns all around the world. In the Supreme Court, we had a battery of lawyers. So the original group of, I think, 3 or 4 persons, Shyam was there and other friends were there, but they were limited to, I think, 3 or 4 litigants. You had a battery of about 30 lawyers with all sorts of interests. And you now had arguments on religious basis, on medical basis and on penal basis. Now, so far as religious view is concerned, I think we are not going to tarry any further on it, because the person who genuinely believes the text of his religion might get up and say that in my book says this is sin or this is sinful, and therefore that is the end of the argument. And my answer to him would be very simple, that please follow it yourself. This is not some statute compelling you to behave in a certain way. This is a liberty which has been recognized by the society. But it is very interesting that the religious arguments are sometimes the most extreme ones, because you have the imprimatur of God to what you are saying, and therefore the arguments don't really brook of any acceptance, adjustment with the current view. And it's also interesting how religious people are among the most fanatic in some ways on this issue. And it's ironic in a way, because if you read Christopher Isherwood's introduction to the Upanishads, translated by Prabhavananda, he says how wonderful it was to go to a Vedantic teacher and find that my gay character was not an issue at all. He says, you are one like any one of us, we don't even want to go into it. There is no question of sin and no question of repentance. As against the cases which we have referred to earlier, the period of gestation of the Supreme Court judgment was about 18 months, which I am told is the period for an elephant. Because that's now, at the end of it, we have judgments which, in my view, has some 4 very serious flaws. And I want to mention them first, and rather than go into questions of interpretation of a particular article or a particular section, I would like to just give the broad view I have on what these problems are and how do we identify it. First is, the Supreme Court has virtually avoided what I regard as the most important issue as to what is sexual orientation. See, the whole argument, I will show to you that it was raised. The point was made. Supreme Court has said nothing about it excepting referring to some case on abortion which has nothing to do with this issue at all. So I am just putting that issue, I will discuss it a little later. So this has been ducked in my view, and it has been bypassed. Second is, Supreme Court has been very hesitant in being forthright enough to say what are the acts which are forbidden under 377. This is extremely critical, because as I am going to show, the judgments that the Supreme Court itself was candid enough to refer to include so many acts which make 377 a majority crime and not a minority crime. I am going to demonstrate that to you in a moment. But Supreme Court hasn't dealt with it. In fact, Supreme Court has come with an extremely strange argument that this is so uncertain that we can't decide except on a case by case method as to what is criminal and what is not under 377. Third, and to my mind this is the fatal flaw, is that the section on rape which they have set out is the wrong section. It is a section which has been repealed and replaced by some other section. And I want your reaction to that, because the way I read 375 today, an oral relationship with a woman with her consent is not a crime. It is expressly taken out of 375. Now it would be a very strange thing that you define rape now, say that this is not rape, but then you by some side wind, you bring it into the other section, unless you say the section doesn't cover this act. But I want you to see that, and I think we are going to have the section set out. Section has been set out. I won't turn back, but you tell me if you can read it or not. But I'll go to that later. That's the third thing. And the fourth point is what the lawyers love to call ipsi dixit, that is, I say so. You say it from ex cathedra, from the pulpit, that this is a minuscule community. And this minuscule argument also I will tell you where the origin is in the judgment. But that has two terrible flaws. One, it is not minuscule if you take the judge's own definition of what this sort of conduct is. Secondly, it is certainly not minuscule if they had bothered to go into the actual material which was presented to them. And I will just give you the Outlook survey which was given to them, and they read it. Or I often assume they read it, because we can only give it to them and say, your Lordship will turn to page 33 and hope we do it. Therefore the question is that if these four flaws are to be found there, this judgment is really, lawyers love to say per incurium, which means they have not noticed something, but it is not there. I think at the end of 18 months, the judgment to my mind, and these are astute judges, let me tell you, these are judges who have given judgments which are extremely sound in the areas of public accountability, in the area of the state being a trustee. This judgment shows some, let me say, it's a peculiar suggestion to make, but it shows some hurry. Hurry after 18 months is a little odd to say, but I think you probably know that the judgment was delivered on 11 December 2013. I remember it because it's 11, 12, 13. And that was the last day on which Justice Singhvi was sitting. And it was, now there is nothing wrong about waiting for 18 months and delivering a judgment. But I think the judgment does show, to my mind, some sign of hurry. There is a lot of padding involved in considering certain issues like classification and all presumption of constitutionality, which are really totally unnecessary when you are discussing a matter in the Supreme Court. Now, having put this, let me just go to the first question of sexual orientation. Now, let me tell you, this to my mind is the fulcrum of the case. Because unless you understand that there are some persons whose orientation is such that they will not get, I am using the word of the language, euphoria in sex unless they have relationship in a particular way. Unless you understand that, you will never be able to approach this case in a manner in which it should be approached. This is not to come to a value judgment whether it is right or wrong, but it is a fact of life. And the court has to squarely face this and say, what exactly is the act that we are considering and we are discussing? Is it, as our opponents pointed out, a sin? then there is no argument, because then it's a sin, and as I said, you should not commit sin, but don't force others to follow your rules. Or is it a crime by its very terms? And I would just point out to you that this expressly was noted by the judges, but they have not really answered it, which is a statement which they made in setting out who is arguing what, that the appellant submit, this is the Dr. Shekhar Sheshadri and others, on behalf of the National Institution of Mental Health, that the applicant submit that the sexual orientation is an immediate, is an immutable characteristic and it's present at birth. Now you have to face it. If you want to say that this is a crime, then you must face it. You say this is wrong. Of course you can say this is wrong. But you can't just duck it. And the judges have had a very curious approach, that this is an action, you're citing cases from outside India, and the Delhi High Court is full of cases from America and Canada and Australia, who are slightly oddballs to start with. I mean, that's the underlying argument. But I would suggest that if this is a part of sexual orientation, it's a matter of human nature. When is the question of a particular country being involved? I was telling someone that even Eskimos do it. So, I mean, Cole Porter's famous poem, even Eskimos do it. What's the point of saying that Indians don't do it? And as I would suggest, as I showed from Prabhavanand's own, Christopher Isherwood on Prabhavanand, that it was accepted and taken in its stride by Hindu priests. Now it's very curious that today the Archbishop of Canterbury can appoint a bishop, I think a bishop who is openly gay, but in India he would perhaps be committing a crime. Therefore the foreign views also become relevant if you go into the question of sexual orientation, which I am afraid has not been dealt with.